This conference will now be recorded.
All right, so you should be able to go ahead. Thank you, Elia Ellis.
Okay, good morning, everybody. This is Elia Elis, attorney at law, and I'm happy to be with you this morning and to address the question of when a board or an association should take a rules enforcement matter to court, when to file a lawsuit, or when to take an alternate approach. Um, in order to answer that question, I just want to lay out the basic framework, which I know most of you already know, that we have community associations that are governed by governing documents, condominium declarations, subdivision indentures, and the like. And within that, most associations also have sets of um, restrictions on use of property, and then rules with respect to um, use of the property and behaviors amongst the neighbors. And so the question is, when there are violations of those restrictions or those rules, how do we deal with those, and at what point should a board consider taking a matter as far as a lawsuit in court? Um, so the normal progression for dealing with a violation of the rules or of a restriction would, of course, be to first have the board, through its managing agent, reach out to the violator, whether it's by a phone call or a first sort of notice or a violation, and make them aware of the problem and try to get them to voluntarily resolve the issue and correct the violation or the non-compliant situation. Um, if the resident fails to comply, um, there may be a sequence of letters in the association's procedure to ratchet up to a more stern letter a second time, and an even more stern letter with other threats of fines or legal action in subsequent letters in order to get and gain compliance. Ultimately, if the association, and most do, have the ability to impose fines, a fine might be threatened and then might be actually imposed for continued violation or for new violations of the same problem. And each and every homeowners association usually does and should have some sort of due process provision in their governing documents, meaning that when an owner or a resident gets a notice of violation, they have the right to request a hearing before the board, to confront the evidence against them for the violation, to appeal or rebut the allegation against them, and to try and work out or mediate something with the board to resolve the problem. So that's the due process: the notice of the violation, the notice of the intent to fine, and an opportunity for the accused to be heard and to present their case before a final decision is entered by the board. That's critical in the process. If the violation still cannot be resolved because the resident owner is obstinate, or there's a disagreement on whether they're in violation or not, and the board needs to take the next step, there could be additional fines. We've already sort of covered that. There could be liens to secure the fines against the property. You would hope that with the ratcheting up of these steps, that an owner or a resident, whoever the target violator is, would ultimately capitulate because of these increasing fines and the lien against the property. And perhaps at some point, there's going to be a discussion with the board and the legal counsel for the association to say, hey, we've done all these steps that I've just described, and the owner still refuses to comply, or the resident to come into compliance. What do we do? And at that point, the review with the lawyer should be to make sure that the rule that's being violated is clear, that the violation itself is clear and well documented, that the due process that I mentioned a few minutes ago has been offered and gone through if accepted in terms of a hearing. And then if there's still no resolution, the next step might be a cease and desist letter from the lawyer on behalf of the association with threats of lawsuits or even potentially foreclosure of the lien for the fines, whatever threats might seemingly under the circumstances motivate the violator. And so now we're really, if we've gone, I just wanted to cover all that as basic framework before we get to the question of the day of when to file suit. So all these things that I've just described should happen first. And now the board's at a place where they've tried all these things and without satisfaction or resolution. And so the discussion with the lawyer, okay, now what, do we file suit? And so the answer is never going to be a one size fits all, although one of your operating principles, of course, is you want to, if you have rules in your governing documents, they're there to be enforced. And if you don't enforce them, why do you have the rules? And so the general operating principle is going to be, yes, we're going to enforce our rules. And if it requires us to file suit, yes, we're going to do that. But there's a big caveat because sometimes filing suits are impractical. Sometimes in analyzing the case with the lawyer, there may be a conclusion that there's some legal weaknesses to the case, and that if we spend the time and money going to court, it may not be successful. And so we should probably look to some other resolution or to back down, depending on the circumstances. We need to talk with the board about what the costs of the suit are, what the likelihood of success is. Another important factor, of course, is being consistent from case to case. Have we had other cases like this in the community with the same sort of rule violation? And what have we done about it in the past? Have we consistently enforced it? Is there a genuine, valid, meritorious reason not to enforce it in this case that we could document as a board and grant, let's say, a waiver to the owner or the resident who's violating because there's a legitimate reason not to enforce the rule in this particular case, but one that we can document and distinguish from the next time. So these are all kinds of the considerations and factors that have to be analyzed. There's also, before considering litigation, other alternative dispute resolution methods such as mediation or arbitration that could be considered. Mediation, of course, could be self-mediation, meaning the parties get together in a room and try to resolve their problems. Maybe the offending resident or owner gets a lawyer for themselves, and the association has its lawyer, and everybody gets in a room and tries to resolve the issue by themselves. Mediation could also be with a hired mediator, a third-party neutral, who gets everybody into the room and tries to foster a voluntary resolution of the issue. Mediation is always implies voluntary participation by the parties. Another alternative, as I mentioned, is arbitration. Arbitration is sort of more akin to a lawsuit, but it's not in court. It doesn't have the time and expense and all the rules of civil procedure that a lawsuit does, but it is an opportunity to have an arbitrator who acts like a judge to hear the case, typically presented by lawyers on behalf of each of the parties in one single, more informal hearing than a lawsuit, and let the arbitrator make a ruling that is binding, just in the same way that a court judgment would be binding on the matter. So those are a couple of different ways before or instead of a lawsuit that issues like rules violations could be resolved without the time and expense of litigation. What are the kinds of cases that probably have to go to litigation, or I should say more likely to go to litigation? Obviously, Small ones, let's say an owner's failing to clean up after their pet in the common areas. Is that a case that you want to take to trial about dog uh, waste? Probably not. But what if somebody's, you know, failing to comply with the rules for months and months and months or years and years and years? I think I was involved with a case years ago where it was ruining the lawn, because of the dog waste, and so there was an expense to the association in the common areas. It wasn't just the nuisance of it, but there was actual modest property damage to be reckoned with as well. But I would say the more, for lack of a better phrase, the larger cases that might um, a board might be more likely to consider taking to court would be architectural violations. Someone puts up a deck or some kind of improvement to their property that hasn't been approved by the board or the architectural review committee, and is clearly inconsistent with not only the rules but the aesthetics of the community. That would be an obvious or more obvious instance where it's a significant violation, where the owner has made a monetary commitment of his own or her own to um, improve their property, but without um, permission, and that needs to be. It's only going to be probably by a judgment of a judge that they're going to be uh, willing or required or forced to take down what they have built. So that's one example. I think of a case that would probably have to go to suit if it couldn't be voluntarily resolved. Behavioral issues like nuisance issues that are ongoing and um, can't be resolved by some of the preliminary steps that we resolved, could require a lawsuit. I'm thinking back now to a case I had a couple of years ago with a hoarder in a condominium, where the problem was so bad, of course, that it was creating horrible smells and pest conditions in neighboring units. Um, and we had to go to court and get court orders to get the person out, to get hazmat teams in the unit, and that sort of thing. So that was a situation where, and of course, hoarding is got some psychological or emotional components to it, so it's very difficult to deal with, and you can't just reason necessarily with somebody to get the problem resolved. So there's another example. Um, in HOA circumstances, non-compliant fences are fairly common subject matter for a lawsuit. People get very adamant about their fences, and don't want to remove them. And if they haven't put in compliant ones or gotten permission, and that's one that all the other neighbors see, and so you want to be consistent in your application of enforcement of the rules in that sort of case. So um, I guess the summary is there isn't a one size fits all answer for when to go to court. It's going to be a discussion only after going through all the other less severe and significant steps that I described, trying to resolve the problem. It's going to be an analysis between the board, the manager, and the lawyer for the association as to the circumstances. Is the rule clear and clearly able to be enforced? Are the factual circumstances of the person's violation? Is there any ambiguity about whether they're in violation or not? Have we given the person due process? Have we gone through all the steps of giving the notices and tried all the other preliminary steps? And is this a violation that is, for lack of a better phrase, significant enough that it warrants taking it to court and getting a judge to help the association enforce it? So that is my summary of the topic. I'm happy to entertain questions or address specific instances that you might have on your mind, if you like.